Republic Act Number 9262, or the Anti-Violence Against Women and Their Children (VAWC) Act of 2004. It is a law that seeks to address the prevalence of violence against women and their children by their intimate partners like their husband or ex-husband, live-in partner or former live-in partner, boyfriend or girlfriend or ex-boyfriend or ex-girlfriend, dating partner or former dating partner. This law classifies VAWC as a public crime. Violence against women and their children refers to any act or series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. VAWC refers to abuse committed by a person against a woman who is his wife or former wife, or with whom he has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate. These are those below 18 years of age or older but are incapable of taking care of themselves, as stated in Republic Act Number 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. These also includes biological children of the victim and other children under her care. Victims, survivors. Women and children who are victims of violence are also referred to under the law as victim survivors. The victim survivor need not necessarily be the wife or former wife. She could be any woman who the offender had a sexual relationship or dating relationship. Whether the sexual or dating relationship had ceased is immaterial for as long as there is sufficient evidence showing the past or the present existence of such relationship between the offender and the woman, victim survivor, when the harm was committed. Sexual relationship refers to a single act which may or may not result in the bearing of a common child. Dating relationship neither refers to casual acquaintances nor to ordinary socialization in a business or social context. It refers to a situation where the parties live as husband and wife without the benefit of marriage or are romantically involved over time and on continuing basis. The dating relationship contemplated under the law can exist even without a sexual intercourse taking place between those involved.
Scope of violence. Violence against victims, survivors is not confined with physical violence. It includes sexual violence, psychological violence, or economic abuse. For physical violence, under physical violence, it is either in the infliction of bodily harm, it could be in the form of battery, assault, coercion, harassment, or arbitrary deprivation of liberty. Battery means or battery refers to an act of inflicting physical harm upon the victim survivor, resulting to physical and psychological or emotional distress. Next is sexual violence. Sexual violence can be in the form of rape, sexual harassment, acts of lasciviousness, treating the victim survivor as a sex object, making demeaning and sexually suggestive remarks, physically attacking the sexual part of the body, forcing the victim survivor to watch obscene publication and indecent shows, or do indecent acts or make film thereof, forcing the woman or victim survivor and a mistress or lover to live in the conjugal home or sleep together in the same room with the abuser or offender. Acts causing or attempting to cause the victim survivor to engage in any sexual activity by force, threat of force, physical or other harm, or threat of physical or other harm, or coercion, or prostituting the victim survivor. Let's have now the psychological violence. Psychological violence refers to acts or omissions causing or likely to cause mental or emotional suffering of the victim survivor, such as intimidation, harassment, damage of property, public ridicule or humiliation, repeated verbal abuse, marital infidelity, causing or allowing the victim survivor to witness the following: the physical or sexual or psychological abuse of a member of the family to which the victim survivor belongs, pornography in any form, abusive injury to pets, unwanted deprivation of the right to custody and or visitation of common children, or stalking in the act of following the victim survivors or putting the victim survivors under the surveillance without justification. Next is economic abuse. Economic abuse refers to acts that are intended to make the victim survivor financially dependent, such as withdrawal of financial support, preventing the woman or the victim survivor from engaging in any legitimate professions, occupation, business, or activity except when the same is based on valid, serious, and moral grounds as defined in Article 73 of the Family Code of the Philippines. Deprivation of or threat of deprivation of financial resources, including the right to the use and enjoyment of the conjugal, community, or the property owned in common. Another is destroying household property and controlling the victim survivor's own money or properties, or solely controlling the conjugal money or properties.
Remedies of victim survivors. Criminal action. A criminal action may be resorted to when the act of violence against victim survivors is committed through any, some, or all of the nine means which Section 5 of the law specifies as constitutive of crime. If found guilty, the offender shall suffer the penalties stipulated under Section 6. Example, imprisonment and payment of a fine. In addition, said offender shall be made to undergo psychological counseling or psychiatric treatment. Criminal action with reservation of a separate civil action. When a criminal action is also available and is resorted to, the civil action for damages is deemed instituted with the criminal action, unless an independent civil action for damages is filed. Civil action for damages. Section 36, damages. Any victim of violence under this act shall be entitled to actual, compensatory, moral, and exemplary damages, and protection order without claiming damages. Crime of VAWC. A. Causing physical harm to the woman or her child. B. Threatening to cause the woman or her child physical harm. C. Attempting to cause the woman or her child physical harm. D. Placing the woman or her child in fear of imminent physical. E. Attempting to compel or compelling the woman or her child to engage in conduct which the woman or her child has a right to desist from, or desist from conduct which the woman or her child has a right to engage in, or attempting to restrict or restricting the woman's or her child's freedom of movement or conduct by force or threat of force, physical or other harm, or threat of physical or other harm, or intimidation directed against the woman or child. This shall include but not limited to the following acts committed with the purpose or effect of controlling or restricting the woman's or her child's movement or conduct. You can see in the list below. F. Inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her actions or decisions. G. Causing or attempting to cause the woman or her child to engage in any sexual activity which does not constitute rape by force or threat of force, physical harm, or through intimidation directed against the woman or her child or her or his immediate family. H. Engaging in purposeful, knowing, or reckless conduct, personally or through another, that alarms or causes substantial emotional or psychological distress to the woman or her child. This shall include but not be limited to the following acts. See the list below. I. Causing mental or emotional anguish, public ridicule, or humiliation to the woman or her child, including but not limited to repeated verbal and emotional abuse, and denial of financial support or custody of minor children, of access to the woman's child or children.
Penalties and prescriptive periods for the acts causing physical harm to the woman or her child. The penalties are: acts constituting attempted, frustrated, or consummated parricide or murder or homicide shall be punished in accordance with the provision of the revised penal code. If these acts resulted in mutilation, it shall be punishable in accordance with the revised penal code. Those constituting serious physical injuries shall have the penalty of prison mayor. Those constituting less serious physical injuries shall be punished by prison correctional, and those constituting slight physical injuries shall be punished by arresto mayor, with a fine of not less than 100,000 but not more than 300,000. Mandatory psychological counseling or psychiatric treatment, and reporting compliance to the court with the prescriptive period of 20 years. Also, under penalties and prescriptive period for the acts of threatening to cause the woman or her child physical harm, the penalties are imprisonment of 2 degrees lower than the prescribed penalty for the consummated crime as specified in the preceding paragraph, but shall in no case be lower than arresto mayor, with a fine of not less than 100,000 but not more than 300,000, with a mandatory psychological counseling or psychiatric treatment and reporting compliance to the court. Of course, the prescriptive period is also 20 years. For the acts of attempting to cause the woman or her child physical harm, the penalties are arresto mayor, with a fine in not less than 100,000 but not more than 300,000, and mandatory psychological counseling or psychiatric treatment and reporting compliance to the court with a prescriptive period of 20 years. Also, for the act of placing the woman or her child in fear of imminent physical harm, the penalties are arresto mayor, fine with a cost of not less than 100,000 but not more than 300,000, with a mandatory psychological counseling or psychiatric treatment and reporting compliance to the court with a prescriptive period also of 20 years. For the act attempting to compel or compelling the woman or her child to engage in conduct which the woman or her child has the right to desist from, or desist from conduct which the woman or her child has the right to engage in, the penalties are: we have prison correctional, fine in not less than 100,000 but not more than 300,000, with a mandatory psychological counseling or psychiatric treatment and reporting compliance to the court with a prescriptive period of 20 years. For the acts of attempting to restrict or restricting the woman's or her child's freedom of movement or conduct by force or threat of force, or physical or other harm or intimidation directed against the woman or her child, the penalties are prison correctional, with a fine of not less than 100,000 but not more than 300,000, with a mandatory psychological counseling or psychiatric treatment and reporting compliance to the court with a prescriptive period of 20 years. For the act inflicting or threatening to inflict physical harm on oneself for the purpose of controlling her action or decisions, the penalties are arresto mayor, with a fine in not less than 100,000 but not more than 300,000, with a mandatory psychological counseling or psychiatric treatment and reporting compliance to the court with a prescriptive period of 20 years.
Penalties and prescriptive periods. A. Causing or attempting to cause the woman or her child to engage in any sexual activity which does not constitute rape by force or threat of force, physical harm, or through intimidation directed against the woman or her child or her or his immediate family. Penalties. Prisión mayor. Fine in the amount of not less than 100,000 pesos but not more than 300,000 pesos. Mandatory psychological counseling or psychiatric treatment and reporting compliance to the court. Prescriptive period 10 years. Act. Engaging in purposeful, knowing, or reckless conduct personally or through another that alarms or causes substantial emotional or psychological distress to the woman or her child. Penalties. Prisión mayor. Fine in the amount of not less than 100,000 pesos but not more than 300,000 pesos. Mandatory psychological counseling or psychiatric treatment and reporting compliance to the court. Prescriptive period 10 years. Act. Causing mental or emotional anguish, public ridicule, or humiliation to the woman or her child, including but not limited to repeated verbal and emotional abuse, and denial of financial support or custody of minor children, of access to the woman's child or children. Penalties. Prisión mayor. Fine in the amount of not less than 100,000 pesos but not more than 300,000 pesos. Mandatory psychological counseling or psychiatric treatment and reporting compliance to the court. Prescriptive period 10 years.
Aggravating circumstances. The penalty shall be the maximum period of the prescribed penalty in the foregoing act were committed, while the victim survivor is pregnant, or in the presence of the victim survivor child. Aggravating circumstances. The penalty shall be the maximum period of the prescribed penalty in the foregoing act were committed, while the victim survivor is pregnant, or in the presence of the victim survivor child.
Battered woman syndrome refers to a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships as a result of cumulative abuse. Women who are suffering from this syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the revised penal code. A woman, victim survivor, is not disqualified from having custody of her children simply because she is suffering from this syndrome. In no case shall custody of minor children be given to the offender of a woman victim survivor suffering from such syndrome. Public crime. Violence against victim survivors is a public offense. Therefore, it may be prosecuted upon the filing of a complaint by any citizen having personal knowledge of the circumstances involving the commission of the crime.
Exemption from liability. Any person, private individual, or police authority, or barangay official who act in accordance with the law, responds, or intervenes without using violence or restraints greater than necessary to ensure safety of the victim survivor is not liable for any criminal, civil, or administrative liability resulting therefrom.
No compromise on crimes involving violence against women and their children. Compromise on any act constituting the crime of violence against the victim survivors is not allowed. Other prohibited matters of compromise. The court shall also not allow compromise on the following matters: civil status of persons, validity of marriage, declaration of nullity or annulment of a marriage or of a legal separation, grounds for declaration of nullity or annulment of marriage or legal separation, future support, the jurisdiction of court, and future legitime. The venue of criminal action. The regional trial court, designated as a family court, has original and exclusive jurisdiction over cases of violence against victims survivors. If there is no family court in the place where the offense was committed, the case shall be filed in the regional trial court where the crime or any of its elements was committed. The law contemplates that acts of violence against women victim survivors may manifest as transitory of continuing crimes.
Protection order issued by a pertinent authority to prevent further acts of violence against women and their children, their family, or household members, and to grant other necessary relief. Victim survivors can apply for a protection order to prevent further acts of violence against them, minimize disruption in their daily lives, and facilitate the opportunity and ability to independently regain control over their lives. Protection order forms: barangay protection order, temporary protection order, and permanent protection order. Who may file petition for protection orders? A. The offended party. B. Parents or guardians of the offended party. C. Ascendants, descendants, or collateral relatives within the fourth civil degree of consanguinity or affinity. D. Officers or social workers of the DSWD or social workers of local government units. E. Police officers, preferably those in charge of women and children's deaths. F. Punong barangay or barangay kagawad. G. Lawyer, counselor, therapist, or healthcare provider of the petitioner. H. At least two concerned responsible citizens of the city or municipality where the violence against women and their children occurred and who has personal knowledge of the offense committed. The filing of a petition for protection order by the victim survivor suspends the right of all other authorized parties to file similar petitions. A petition filed by the victim survivor after the filing of a similar petition by an authorized party shall not be dismissed, but shall be consolidated with the petition filed earlier.
To obtain a protection order. To obtain protection order, a written petition signed and verified under oath by petitioner must be filed using the standard protection order application form, which should contain, among others, the following information. Letter A. Names and address of petitioner and respondent. Letter B. Description of the relationship between petitioner and respondent. Letter C. A statement of circumstances of the abuse. Letter D. Description of the relief requested by petitioner as specified in Section 8 herein. Letter E. Request for counsel and reason for such. Letter F. Request for waiver of application fees until hearing. And letter G. An attestation that there is no pending application for protection order in other court. If the applicant is not the victim survivor, the application must be accompanied by an affidavit of applicant attesting to: letter A. The circumstances of the abuse suffered by the victim, and letter B. The circumstances of consent given by the victim for the filing of the application. When disclosure of the address of the victim will pose danger to her life, it shall be stated in the application. In such a case, the applicant shall attest that the victim is residing in the municipality or city over which court has territorial jurisdiction and shall provide a mailing address for purpose of service processing.